Hello, good morning. Thank you for joining us at Handley Gill today for the first in our series of webinars on the Data Use and Access Act 2025. Today's session is going to be an overview of the Data Use and Access Act and its implications for data protection. We are also running a session this afternoon on the implications for law enforcement processing, where we're going to be looking explicitly at the implications for processing under Part 3 of the Data Protection Act. So we're not going to cover that in this morning's session. So if that's something you're interested in, you can sign up. The link for that is on our the events page of our website. There's also an Eventbrite page for the event. So if that's something you're interested in, please do go and sign up for that session. I know some of you are signed up for both this afternoon and this morning, so apologies to you. This is not intended to be a punishment. We've also got a session on Monday of next week where we will look and do a deep dive into the changes for websites and marketing. So again, we're not going to cover that in this morning's session. We're not going to have time. There is so much material to get through. So if you're interested in what this means for your cookies, what you need to do, what the opportunities are around marketing, communications, that kind of thing, then please do sign up for our session on Monday. If you want to, if you're unavailable to attend a session, please do sign up in any event, because we will send out materials from the event afterwards. We'll make recordings available. We'll send out the slides and any related materials. There'll be blog posts relating to each of these events as well. And we're also intending to send out the kind of our Keeling schedules, if you like, so showing what the changes the Data Use and Access Act 2025 will make to the Data Protection Act 1998, which is still relevant for marketing and PECA enforcement in particular, to the Data Protection Act 2018, to the UK GDPR. And you'll be able to see those, but that will show what they will look like once all the provisions are in force, which is something we're going to talk about shortly. So I've done that little introduction. I've given it kind of a couple of minutes, so hopefully people are joining us. So at this point, I am going to share the slides and we will get going. If anyone has any questions throughout the course of the session, please do pop that in the Q&A box. I can see those. I will try and either pick them up as we go, or I'm really hoping that we'll have time to cover off questions at the end. So allow me to share our presentation with you. Okay. My name is Nicola Kane. I'm the CEO and Principal Consultant at Handley Gill. We are an award-winning legal and regulatory compliance consultancy. We have specialisms in data protection, AI governance, online safety, and kind of related human rights and ESG issues. So in terms of what we're going to cover during this morning's session, we're going to mention the structure of the Data Use and Access Act. We're then going to talk about commencement of the Act. We're then going to look at the provisions that have an immediate impact, things you need to know and have changed right now. And then the bulk of the session is actually going to be dealing with prospective changes. So the changes that the Data Use and Access Act will introduce when they are commenced. And in relation to each change, we will aim to talk about what the nature of the change is. We'll look at the text of the change, and then we'll talk about its practical impact, what you actually need to do about it, either now or when the provision is brought into force, the things you'll need to think about and do then. And that gives you some time and some scope, hopefully, to start thinking now about when this is brought into force, what would we need to do? What more resources would we need? Or what opportunities does the change give us, and to start building that thinking up now and to start implementing some of the measures that will help you do that in due course. When we show you the text of the change, please don't panic. Some of the text is going to be quite small on the screen. I am going to talk you through it. The real reason for having that is so that when we send out the slides, you can see the changes. And as I say, we'll also send out the kind of Keeling schedules showing the changes as a separate document. So the Data Use and Access Act. Royal assent was granted on the 19th of June, so almost a month ago now. The Act actually covers a range of things. So it was in 8 parts. The first part dealt with access to customer and business data, which actually isn't really a data protection issue, although it sounds like it could be. That's thinking about the circumstances in which it could be for competition reasons, it could be for other reasons, it could be with a view to helping establish data sets for the development of AI, for example. The government could make regulations requiring the disclosure of information about businesses, their products and their customers. Part 2 deals with digital verification services, thinking about, things like national ID. Part 3 dealt with the National Underground Asset Register. So basically, where the pipes and everything else are under the street. So with a view to actually helping companies be a lot more efficient. Part 4 deals with registers of births and deaths. Part 5, explicitly about data protection and privacy. Part 6 is about the Information Commission. Part 7 has kind of a range of miscellaneous provisions, and then Part 8 are just the final provisions. So the purpose of today's session, we're going to be focusing on Parts 5 and 6 of the Data Use and Access Act 2025 and the amendments that makes to the UK GDPR and the Data Protection Act and PECA, although really the PECA bit is going to be in Monday's session. So the next thing to talk about is commencement. Section 142 of the Data Use and Access Act 2025 provides for the commencement of certain provisions, some upon royal assent, others 2 months thereafter, and others in accordance with regulations made by the Secretary of State. As of yet, no commencement regulations have been made in respect of the Data Use and Access Act. So the only provisions we're working with are those highlighted in section 142. The provision that you need to know about that has an immediate impact is section 1422B of the Data Use and Access Act brings into force section 78. That relates to the scope of searches you're required to undertake in response to data subjects' requests. And that is in force as at the date of royal assent. So let's look at that first. Up on the screen, hopefully you can see, as I say, if not, don't panic because we'll circulate these separately. On the left-hand side is section 78 of the Data Use and Access Act 2025 and the amendments it makes. And on the right-hand side, we're showing you Article 15 of the UK GDPR with those amendments put in. And essentially what section 78 does is to include a provision in Article 15 of the UK GDPR on the right of access by the data subject and provides that under paragraph 1, so the right of access, the data subject is only entitled to such confirmation, personal data, and other information as the controller is able to provide based on a reasonable and proportionate search for the personal data and other information described in that paragraph. So you may well be very familiar already with the concept under the litigation under the 1998 Act that said that you only have to do a reasonable and proportionate search in response to a data subject access request. What the government's doing is just codifying that the jurisprudence under the preceding legislation and making clear that that applies to requests under the UK GDPR. One thing that is important to note is that section 78(5) of the Data Use and Access Act 2025 that introduces that amendment states that the amendments by this section are to be treated as having to come into force on the 1st of January 2024. Consequently, that provision that you only have to do a reasonable and proportionate search has retrospective effect to the 1st of January 2024. It's not entirely clear why the government picked that date or decided to do that, but that is what they have done. So as of right now, your obligation, if you get a subject access request and in respect of any request you have already dealt with, since the request was made, it was made on or after the 1st of January 2024, you only have to conduct a reasonable and proportionate search for the data. So something to think about then is in your own guidance, in your own templates, when you're responding to requests, for example, you're going to want to update those right now to reflect that when you're doing a search, if someone says, for example, I want all personal data relating to me, you only need to do a reasonable and proportionate search. And so you can think about what the scope of that search might be. Moving on now to the prospective changes. This is where the bulk of what we're going to cover today is going to be. There are a range of things, areas that the Act addresses, and we've tried to collate these thematically. So, legitimate interest, lawful basis, processing for the performance of a task carried out in the public interest, special category personal data, processing for research and statistical purposes, complaints, purpose limitation, data subject rights requests, automated decision making, children's personal data, codes of conduct, restricted international data transfers, the Information Commissioner in relation to its structure and focus, the Information Commissioner, or as we'll come to, the Information Commission in relation to transparency, the Information Commission in relation to guidance, and then data protection enforcement. Now, it's important to note these are all prospective changes, save that insofar as the provisions give the Secretary of State power to make regulations, the power to make regulations is in force as at royal assent. But until those regulations are in fact made, the changes do not apply. So in respect of all of these, you'll note, we'll come to it, and what we're saying is you need to keep monitoring. You need to be alive to the fact that we are going to be expecting potentially a slew of regulations under the Data Use and Access Act within, an unspecified currently time period. So you need to just be mindful of what's coming up, keep an eye on this stuff, make sure you're signed up, to relevant, maybe on LinkedIn, follow people on LinkedIn. You can follow us on LinkedIn, or on LinkedIn as Handley Gill Limited. And I'm personally, you can also follow me, Nicola Kane, or us to connect. And we post stuff there. Sign up to our newsletter or take an RSS feed of our blog posts. Other people and other entities will also be posting about stuff. People like DPO Daily and others who are also really, really good. So just be mindful and keep an eye out, because things are going to keep changing. So we're going to kick off, hopefully, yeah, here we go, with recognised legitimate interest, so lawful basis. So Article 6 of the UK GDPR establishes the lawful bases, the grounds on which you're entitled to process personal data. One of those is that of legitimate interest. So it's in the legitimate interest of the controller or another person to process personal data, and that processing, those interests are not outweighed by the interests of data subjects in their rights and freedoms in data protection. What Section 70 and Schedule 4 of the Data Use and Access Act 2025 will do is to introduce a new additional lawful basis for processing personal data under Article 6, and that is of recognised legitimate interests. It does that by incorporating new provisions into the UK GDPR, Article 61EA of the UK GDPR and Annex 1, and making consequential amendments. So let's have a look at what that does. So Article 6 has your lawful grounds for processing, consent, necessary performance of a contract, etc., etc. After the current 61E, which is processing necessary for the performance of a task of the controller carried out in the public interest, etc., there is a new provision, Article 61EA, processing is necessary for the purposes of a recognised legitimate interest. Then you still have 6(1)(f), processing necessary for the purposes of legitimate interest pursued by the controller, etc. There is now a new Article 615 of the UK GDPR. So for the purposes of paragraph 1EA, the new recognised legitimate interest lawful basis, excuse me, processing is necessary for the purposes of a recognised legitimate interest only if it meets a condition in Annex 1. And then the Secretary of State has power to add, vary, or remove recognised legitimate interests at Annex 1. And there are some requirements around the circumstances in which the Secretary of State is entitled to do that, having regard, for example, to the interests, rights, and freedoms of data subjects, whether children will be affected, etc., etc. Annex 1 identifies the recognised legitimate interests that will be in place once this provision is brought into force. Number 1, disclosure for purposes of processing described in Article 6(1)(e). So if a public body says that for the purposes of their carrying out their functions in the public interest, they require certain information, then this will provide a lawful basis for the disclosure of that information. And it still says that the processing has to be necessary for the purposes of making that disclosure, but all it requires is that there has been a request. It effectively removes the burdens and the obligations on the person receiving the request from having to conduct an assessment of their own of whether the request is legitimate. Is that all the requested information really required, etc., etc., in order to ensure that they're compliant. So if you require information from a third party and you're a public body exercising those functions, then this should make it easier for you to obtain information from third parties. It doesn't oblige them to disclose information to you, but where they're willing and able and want to do that, this will help them do that. And so that's something you might want to think about if you're making a request, once this is in force, highlighting this provision to them. The next one, national security, public security and defence. So if processing is necessary for those purposes. Then emergencies, if processing is necessary for the purposes of responding to an emergency within the meaning of the Civil Contingencies Act 2004. If processing is necessary for detecting, investigating or preventing crime or apprehending and prosecuting offenders. If it's necessary for safeguarding vulnerable individuals, that means, and then there's some description around who is a vulnerable individual and what safeguarding means. So those are the new, or will be, the new recognised legitimate interests. And in respect of those, you will no longer need to conduct a legitimate interests assessment. These are just deemed to be legitimate interests. And so the paperwork associated with that will disappear once that's in force. So as we say, what does this mean in practice? It removes the need to conduct a legitimate interest assessment in respect of processing for purposes of any of the recognised legitimate interests once brought into force. Reliance on that new lawful basis once brought into force will require records of processing activities, privacy notices, etc., to be reviewed and updated as necessary, as well as other compliance documentation such as DPIAs. And you'll need to monitor for new regulations being made, expanding or indeed varying or removing, changing the scope of what are the recognised legitimate interests. And of course, you need to keep an eye out for the commencement regulations actually bringing this provision into force. What's next? Performance of a task carried out in the public interest. So Article 6(1)(e) of the UK GDPR. Section 70 of the Data Use and Access Act 2025 revises the wording of the existing legitimate interest lawful basis under Article 6(1)(e) in relation to the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. The change is to make clear, so the wording changes if we're looking at Article 6(1)(e), processing is necessary for the performance of a task of the controller. That's the change. carried out in the public interest, or a task carried out in the exercise of official authority vested in the controller. The point is, it has to be the task of the controller carried out in the public interest. It can't be someone else's task. So it's you relying on your own, if you're the public body, rather than relying on someone else's task. So potentially, depending on how you've interpreted that provision, potentially narrowing. So you'll need to review your records of processing activities, privacy notices, DPIAs, processing agreements, etc., to ensure that where Article 61E of the GDPR is relied upon as the lawful basis for processing, the relevant public interest task or task in the exercise of official authority is that of the relevant controller, not another controller. One other point to note is that I'm trying to go backwards and I'm failing miserably. There we go. Sorry. One other point to note is that there is also a change that the basis for processing in Article 61E must be laid down by domestic or relevant international law. Relevant international law is now specified within the Act, subject to the Secretary of State making regulations to change that. But essentially to authorise processing in relation to disclosure of information under the Cloud Act. So the idea that communication services providers can be required to provide, for example, subscriber information. So that would be the international law. So if you as a public body fulfilling your own tasks requires that information, that is something you can rely upon. So you also need to monitor regulations expanding the scope of what is relevant international law and monitor for these provisions actually being commenced. Next, special category personal data. Section 74 of the Data Use and Access Act 2025 introduces a new power for the Secretary of State to expand the scope of what constitutes personal data subject to the restrictions Article 9 of the UK GDPR. So the prohibition on processing special category personal data, so personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, processing of genetic, biometric data, where it's for the purpose of uniquely identifying someone, health data, or data concerning sex life or sexual orientation. So it will allow him to make regulations to make a wider range of personal data subject to those restrictions, or in what's the way they've done this is said that that's added processing. So if the regulations are made, the Secretary of State can then decide that actually those restrictions should not apply or should apply in a different way to those types of personal data. So in relation to that, you need to monitor for the making of regulations that would expand the scope of special category personal data, subject to restrictions on processing, which could prohibit or require additional compliance to be undertaken to enable continued or new processing of such personal data, and then to keep an eye on what happens thereafter, the nature of any changes to that. In the meantime, though, you're safe to continue. Next, purpose limitation. So you have the idea that once you've collected personal data, you have to collect it for an explicit, legitimate purpose, and then you can only use it for a further compatible purpose, having conducted a compatibility assessment. Section 71 of the Data Use and Access Act 2025 amends the purpose limitation principle at Article 51B of the UK GDPR with consequential amendments, and amends the factors to be taken into account when conducting a compatibility assessment to determine whether further processing is compatible with the original purpose for processing, and establishes several categories of further processing which are deemed to be compatible with the original purpose. So Article 5 just establishes the principles relating to the processing of personal data, and there are some tweaks here. Article 5.3 is new and says, for the avoidance of doubt, processing is not lawful by virtue only of being processing in a manner that is compatible with the purposes for which the personal data was collected. So you can't just say it's compatible and therefore it's okay. You still have to have wider data protection compliance. Nevertheless, the new Article 8A of the UK GDPR makes provision about further processing. What's important is you need to consider some things are the same as it currently applies. So Article 6.4 we'll see is crossed out, but actually a lot of that is replicated in the new Article 8A. So currently you would have to consider any link between the purposes for which personal data have been collected and the purposes of the intended further processing. Article 8A says any link between the original and new purpose, a summarised version, but the same concept. Article 6.4b said you had to consider the context in which the data was collected and the relationship between the data subjects and the controller. That stays in Article 8A.2b. You then had to consider, currently, you would consider the nature of the personal data. Well, under Article 8A, you would now consider the nature of the processing, including whether that includes special category personal data or personal data relating to criminal convictions. So there is a slight change of focus here that could be important in certain circumstances. You would currently consider the possible consequences, and that would still be the case under the Data Use and Access Act changes. And you would also still continue to consider the existence of safeguards. Then you have Article 8A.3, which will be introduced into the UK GDPR, which provides that processing for a new purpose is to be treated as processing in a manner compatible with the original purpose, where there's consent and the purpose is specified explicit and legitimate. Where it relates to scientific purposes, we're going to come back to that. We're going to do a whole section on scientific and research purposes. Where it's carried out for ensuring processing is compliant with obligations under Article 5.1. We had Article 5 up a moment ago. That processing is lawful, fair, and transparent. So compliance with your first data protection principle or demonstrating that it does so. That processing meets an Annex 2 condition, or processing is necessary to safeguard an objective authorised by an enactment or rule of law. And in those cases, you would not have to do your compatibility assessment. Annex 2 to the UK GDPR is introduced. That identifies the categories of processing deemed to be compatible. So processing necessary for making a disclosure to a public body in the performance of its tasks. So replicating what we just discussed under the previous changes. Disclosure for the purposes of archiving in the public interest. Disclosure where processing necessary for the purposes of protecting public security. Processing necessary for the purposes of responding to an emergency. Processing necessary for the purposes of detecting, investigating, or preventing crime or apprehending or prosecuting offenders. Where the processing is necessary for the purposes of protecting the vital interests of the data subject or another individual. Again, processing for safeguarding vulnerable individuals. What does that mean for you? What do you have to do? When that comes into force, you'll need to revise your compatibility assessment templates to reflect the new requirements. You'll want to consider revisiting data reuse projects that have been rejected previously to ascertain whether they could be deemed to be compatible or the assessment of risk could have shifted once the relevant provisions come into force. And you'll want to monitor for the making of regulations that would expand the scope of the categories of further processing deemed to be compatible. Any existing projects that are running, you may also want to look back at those and consider whether you now want to shift lawful basis, whether you want to cease reliance and reference to compatibility assessments and rely on deemed compatibility. Unfortunately, while a lot of this is intended to reduce burdens, the reality is, well, that may be the case going forward, it does introduce more work in the meantime. We're now going to move on to the next change, which relates to data subject rights requests. Section 76 of the Data Use and Access Act 2025 will amend how the time for compliance should be calculated, expanding the grounds for delaying a response to a request and clarifying the grounds on which an extension of time for responding can be claimed. And then also related, Section 104 Data Use and Access Act will provide a mechanism to allow for material subject to a data subject access request, which then becomes the subject of a dispute to be disclosed to the court but withheld from the claimant in any ensuing legal proceedings. So Article 12 is amended. There are two ways in which it's amended that are important. One is that in relation to Article 12A, there is some new provisions inserted. So instead of using the wording that was adopted from the GDPR that you have to respond without undue delay and in any event within 1 month of receipt, you have to respond by the end of the applicable time period, which still means 1 month, but it's from the relevant time. And that time, the clock starts when you have relevant information. That might include confirming identity, for example. The other important change is that it does clarify that when you're entitled to extend the time period by up to a further 2 months where that's necessary, you can do that on the grounds of complexity or number of requests. But what this does is make clear that it's about the requests made by the data subject, not the general number of requests that you're dealing with. Lots and lots of controllers have sought to interpret this provision as meaning that essentially if we're very, very busy or we're under-resourced, we can't manage to deal with the number of requests on our plate right now, we can extend by up to a further 2 months. This provision makes clear that it's only about the number of requests by the individual data subject, not generally, that applies. And then here, this is the change that will be inserted in at section 180A of the Data Protection Act 2018, the procedure in connection with subject access requests. The controller, the court can, but it's not obliged to require a controller to make available information for inspection. But unless and until the court case is determined in the requester's favour, in the data subject's favour, the court cannot require the information to be disclosed to them. Kind of a bit of practical tidying up there. So what will this mean for you? Review, and if necessary, you will need to revise your internal guidance on data subject rights requests, when further information may or should be sought, the circumstances in which an extension may be deployed once the provision comes into force. You'll need to ensure you've got sufficient capacity to handle data subject rights requests within the permitted timescales, and thinking about when and potentially the reduced circumstances in which you're entitled to have extensions. And you'll also want to make sure that you're managing disclosure in the context of data subject access request disputes to ensure that the requested material is withheld. We now move on to automated decision making, and this is one of the areas that was subject to quite a lot of dispute, at least within the data protection community, even if not by MPs, who frankly during the passage of the bill were far more concerned about the implications for copyright and AI and what was missed out of the Online Safety Act than really engaging with the provisions of the Act. Section 80 of the Data Use and Access Act 2025 replaces the current right of data subjects not to be subjected to solely automated decision-making, which produces legal or similarly significant effects, and is reliant on certain lawful bases, and replaces this with an authorization to make automated significant decisions based on special category personal data, provided certain conditions are met, as well as clarifying what constitutes a solely automated decision. So effectively, the rights of data subjects in relation to solely automated decision-making are being reduced. As a controller, your entitlement to conduct solely automated decision-making is being expanded. This is a new opportunity, is intended to try and enable people to take better advantage of AI. So let's have a look what's changed. Article 22 of the UK GDPR, you'll see the current provision all gets deleted when this comes into force. It's replaced by Article 22A to 22D of the UK GDPR. So it starts by saying a decision is based solely on automated processing if there is no meaningful human involvement in the taking of the decision. So that's new. A decision is a significant decision if it produces a legal or similarly significant effect. That's the same. When considering whether there's meaningful human involvement, you have to consider, among other things, the extent to which the decision is reached by means of profiling. The bit about profiling is adopted from Article 22.1 of the UK GDPR currently, but the introduction of this idea of meaningful human involvement is new. The restrictions, Article 22B is what introduces the restrictions on automated decision making. And that is what says that a significant decision based entirely or partly on on processing based on special category personal data may not be taken unless certain conditions are met. And those are either that there is consent, the decision is necessary for entering into or performing a contract between the data subject and the controller, it's authorised by law, or point G of Article 9.2 applies. A significant decision may not be taken based solely on automated processing if the processing of personal data carried out by or on behalf of the decision maker is carried out entirely or partly in reliance on Article 6.1 That is the new recognised legitimate interest. So you've got these new recognised legitimate interests, but they only go so far in providing lawful basis for processing. So that's something to be aware of if you're considering relying on those. There are then safeguards for automated decision making. If based on entirely or partly on personal data and automated decision making. And bear in mind, this is all personal data, not just the safeguards apply to all decisions based solely or partly on automated processing of personal data, not just special category. You do have to have safeguards in place. Those safeguards are that you provide information about decisions, you enable representations to be made, you enable human intervention to be requested and implemented, and you enable decisions to be contested. And then there is also provision for further regulations to be made by the Secretary of State about what does or doesn't constitute meaningful human involvement, what is or is not taken to be a decision having a similarly significant effect, what the safeguards should be, etc. So in practice, you're going to want to review projects where automated processing had previously been rejected to ascertain whether it could be implemented under these new relaxed restrictions once they come into force. You want to look at existing projects as well to consider whether they could be expanded, whether your risk appetite and assessment has changed. You'll need to implement mechanisms to comply with the necessary safeguards in respect of significant decisions involving solely automated decision making once those are in force, and monitor for the making of regulations amending what constitutes meaningful human involvement, a significant decision, and or necessary safeguards which will affect your processing going forward. This is an area where there is a real opportunity and a real kind of meaningful relaxation. When originally the data protection reform was posited, there was a lot of discussion under the previous Conservative government of capitalising on Brexit. We had the Data Protection and Digital Information Bill. We then had the number 2 version of that bill, which then, when the new parliamentary session started, reverted just back to being the Data Protection and Digital Information Bill. And there was a lot of talk about this being a wholly British version of data protection law, something that was going to rip up the rule book. It didn't really do that, but certainly this version, the Data Use and Access Bill, which incorporated lots of provisions that were in the previous bill, but threw out a lot of those that were most controversial and those that potentially had adverse implications, certainly for the European Commission's adequacy decision in respect of the UK. So a lot of the more far-reaching changes have not been incorporated, but this is one of the changes that does have a real meaningful impact and potentially presents opportunities. So it's an area where you can go to your business, to your organization, and talk about, actually, we might be able to do something we couldn't do before and do something differently and use data in ways that make us more efficient, particularly when these changes are looked at together with the purpose limitation changes. And you look at what we're going to come on to next, which is the changes in the meaning for research and statistical purposes. There are real opportunities to think about projects that you wouldn't have thought fell within the concept of scientific research, and particularly in relation to AI development and deployment, how you can use these changes to drive that forward. So let's look at that next. Processing for research and statistical purposes. There are a series of amendments here. Section 67 of the Data Use and Access Act 2025 introduces a new definition of what constitutes scientific research and processing for statistical purposes, significantly expanding their scope. Section 68 of the Data Use and Access Act introduces a revised definition of consent in the context of processing for scientific research. Section 71 introduces a further relaxation of the purpose limitation principle by deeming further processing to be compatible when carried out in the context of scientific or historical research, archiving in the public interest, or for statistical purposes. Section 86 does implement some safeguards for that processing, and Section 77 restricts the information required to be provided to data subjects in respect of such processing. So let's have a look at the changes. The Act introduces new parts of Article 4 of the UK GDPR, which are the kind of definitions for the purposes of the GDPR, and provides that references in this regulation to the processing of personal data for the purposes of scientific research, including references to processing for scientific research purposes, are references to processing for the purposes of any research that can reasonably be described as scientific, whether publicly or privately funded, and whether carried out as a commercial or non-commercial activity. So any research reasonably described as scientific, publicly or privately funded, whether carried out as a commercial or non-commercial activity. This includes processing for technical development or demonstration, fundamental research or applied research, insofar as they can be described as scientific, but there is a caveat in relation to studies in public health. They can only be scientific where the study is in the public interest, but otherwise there is no public interest requirement in relation to scientific research. That was an area that Lord Clement Jones, as I recall, was pushing really hard to make scientific research had to be in the public interest generally. The government threw out those amendments. We then have historical research purposes. That includes processing for genealogical research. Statistical purposes, you have a definition there, processing for statistical surveys, production of statistical results in certain circumstances. Essentially around aggregating data, it's not personal data underlying it. And we then have the definition of consent. So consent in the context of scientific research, you can still have valid, legitimate consent, even if it would not meet the normal requirements of consent, if, when the time consent is sought, it was not possible to identify all the purposes for which personal data would be processed. Consent is consistent with generally recognised ethical standards relevant to that research. and the data subject is given opportunity to consent only for processing for part of the research. So if you're going to be doing either now or want to envisage you might want to use personal data for scientific research in the future, you'll want to go back and be thinking about and looking at your consent mechanisms, what you're asking, are you giving people the right options? We talked about purpose limitation and further processing already, but again, as I mentioned, there are changes so that processing carried out for scientific or historical research, archiving in the public interest, or statistical purposes does fall within the context of the new provisions for deemed compatible processing. Mm. And then the Act introduces a new Chapter 8A of the UK GDPR and Articles 84A to D, which are the additional safeguards, the safeguards that have to be in place if you're doing this type of processing. So you can only be processing for RAS purposes, so research, archiving, statistics. If the processing is the collection of data carried out to convert the data into information, processed in a manner which doesn't permit identification, and without it, you can't fulfill your purposes. You then have your appropriate safeguards. It can't be likely to cause substantial damage or distress. And you can't do it for making kind of medical decisions about individuals, for example. There's also provision for the Secretary of State to make additional regulations about appropriate safeguards and when they are or may not be satisfied. And then at Article 13 of the UK GDPR, your obligations to provide information to data subjects where you collect information from them are modified, where you're processing for the purposes of scientific or historical research. The obligation where you're going to further process data where you would normally, under Article 13.3, you would be required to provide the data subject prior to further processing with information on that further purpose and any other relevant further information. That obligation is displaced. Where doing so would be impossible or would provide or would involve disproportionate effort, having regard to number of data subjects, age of the personal data, and any other appropriate safeguards. That is a much relaxed provision. It is already being relied upon by big tech companies, for example, to say we want to use your personal data for training AI and developing AI, and it's just too hard to have to tell you about it directly. And then similarly, Article 14, you've kind of got a replication of those provisions where if you collected the data from somewhere other than the data subject, the obligation to have to contact and tell the individual is potentially displaced. So what does that mean for you? Review your processing activities to determine whether any could now fall within the scope of the definition of scientific research and benefit from those relaxations once they are in force. But given the kind of scope of the changes, it's something that's worth investigating now. If so, and you intend to rely on this, consider whether you're going to need to revise your privacy notices, your ROPAs, your DPIAs, your other compliance documentation, and make sure you're reflecting this processing activities in your templates. So ensure that they are identified and recorded as such. So, for example, in your DPIA, are you going to add an extra box for identifying could this fall within the scope of scientific research purposes? Next, children's personal data. Section 81 of the Data Use and Access Act 2025 imposes new obligations on information society services likely to be accessed by children to have particular regard to the rights of children in respect of their personal data. This was provision that was pushed in particular by Baroness Keenan, who did a lot of work on online safety. So this amends Article 25 of the UK GDPR, which relates to data protection by design and default. The idea that you have to build in data protection from the outset. And this provides that in addition to that general obligation, in the case of processing carried out in the course of providing information society services likely to be accessed by children, when assessing what are appropriate technical and organisational measures in order to comply with your general obligation of data protection by design and default, you must take into account the children's higher protection matters. Children's higher protection matters are how children can best be protected and supported when using the services, and the fact that children merit specific protection with regard to their personal data because they may be less aware of the risks and consequences associated with processing of personal data and of their rights in relation to such processing, and have different needs at different ages and at different stages of development. There is a carve out for preventive or counselling services, but otherwise information society services, that's very, very broad scope of controller. So you'll need to consider when that is brought into force, whether you fall within the scope of the provision requiring regard to be had to children's higher protection matters. Are you offering information society services likely to be accessed by children? In determining that, regard is likely to be had by regulators and the courts to the guidance by Ofcom in the context of the Online Safety Act as to whether an information society service is likely to be accessed by children. Ofcom and the ICO have been working very, very closely on Online Safety Act issues, and Ofcom has issued guidance on, when a site is likely to be accessed by children. Their general position is that most sites are likely to be accessed by children. If you're offering news, current affairs, even, that you might think, oh, kids don't care about that. No, they do. So it's worth looking to Ofcom's assessment of what likely to be accessed by children means. And essentially their view is most sites are likely to be accessed by children unless you are implementing age gating. And by age gating, their view is highly effective age assurance, which is essentially producing ID or other forms of age verification. So potentially lots of people fall within the scope of these provisions when they're brought in. This would require you to amend your ROPAs, your DPIA templates, and technical organisational measures, your privacy notices, your consent mechanisms, your security measures, to reflect the additional considerations to be given to and recorded in respect of children's higher protection matters. And you'll also want to review and revise all those documents to record the outcome of those assessments you've done. So you'll want to record whether you think you fall within the scope, and if you do, what assessments the new assessments, your refreshed assessments you've made of what this means for children, and taking into account children at different ages and stages of development. There is a children's AI code that has been developed by, I think it's the Five Rights Foundation. We've done a blog post about it on our website, and that does actually have some really helpful kind of breakdowns of children by age and stage of development that might be helpful in thinking about this assessment. Next, codes of conduct. Section 83 of the Data Use and Access Act 2025 amends Article 41 of the UK GDPR to reduce the expectation that failure to comply with an approved code of conduct will necessarily result in the monitoring body excluding or suspending the relevant controllers or processors' adherence to the code. So just essentially making codes of conduct more appealing, more attractive, because they won't necessarily result in an issue in the event of non-compliance. Generally, the Act is more encouraging of codes of conduct, and recognising that they can be valid measures to demonstrate compliance and be able to rely on them more effectively. So if you already operate a code of conduct, consider whether, your code provides the breadth, the permitted breadth of enforcement action, and if not, whether you want to update it and you refresh your authorization for it with the regulator. Once these provisions are in force, you might want to actually give yourself more scope for having lesser penalties. You'll also want to monitor for any changes to existing codes of conduct or codes of conduct you're considering subscribing to. And you might also want to consider whether codes of conduct might be something for you, your organization, your industry, or a particular processing activity where it could be helpful. Next, restricted international data transfers. Section 85 and Schedule 7 of the Data Use and Access Act 2025 pave the way for the Secretary of State to make new adequacy regulations in respect of third countries, reducing the threshold for making such regulations, and then, as a consequence, once those regulations are in place, easing the compliance burden on controllers and processors, on data exporters. So Article 44 of the UK GDPR will go. Instead, we'll have Article 44A of the UK GDPR, which essentially makes provision for regulations to be made. So Article 45 also goes, instead of having transfers on the basis of an adequacy decision, we'll have transfers approved by regulations. And what's important is in what circumstances can regulations be made. And interestingly, it does expand the circumstances or the kind of applications for regulations being made. So it can apply to a sector or geographic area within a third country, a particular controller or processor, recipient, type of personal data, means, etc. So potentially you could have really, really broad regulations being made, or lots and lots of regulations being made. So at the moment, you have the regulations can only be made by the Secretary of State if there is sufficient like the European Commission, if there is adequacy. And that has regard to certain elements. So you would look at the rule of law, respect for human rights and fundamental freedoms, relevant legislation, implementation of legislation, data protection rules, professional rules, enforcement, case law, the role of the regulator, etc., international commitments, those kinds of things. Some of those are still going to be the case, but the threshold is going to be very different. So Article 45B of the UK GDPR introduces the data protection test. That is the standard that must be met, and that is a standard that is not materially lower than the standard of protection provided under the UK GDPR. So under the GDPR in the EU, we've obviously had you've got the GDPR and then you've had the Schrems cases. So it has to be essentially equivalent protection. Here, whilst the UK is saying not materially lower, that is a lower burden, a lower threshold, a lower standard. We can anticipate that the Secretary of State could make regulations where the European Commission would not make an adequacy decision. We also have changes, and one of the important things actually in terms of the factors to be considered, some of them are the same: respect for rule of law and human rights, existence of an authority in the country with responsibility for enforcement, but not considering whether that authority is effective. That's really important. So merely having a regulator who can be completely hopeless, never have enforced anything, that is enough. The existence of it will be enough. So this is going to open up opportunities for more regulations to be made, for more transfers to take place without having to do burdensome, transfer impact assessments, having your safeguards, other safeguards, contracts, etc., in place. But it does represent a weakening of data subject rights. There's also a reduction. So at the moment, you would have to review and conduct reviews, or the Secretary of State would have to conduct reviews of adequacy decisions and regulations. actually there is a lower now burden around kind of just ongoing general monitoring, and only if there's a problem does something have to be revisited. And then there are the consequential amendments around then to match what's an appropriate safeguard. So at the moment, Article 46 of the UK GDPR, you could transfer subject to appropriate safeguards, provided that there are enforceable data subject rights and effective legal remedies for data subjects available. And essentially, you'll be able to transfer effectively where you consider that the data protection test is met. So this lower threshold. Binding corporate rules essentially stay the same apart from the title changes for that article. And there's some further provisions around further regulations that the Secretary of State could make around data protection clauses, specifying those, making further regulations about when a safeguard will meet the data protection test, etc. There's also provision for derogations in the public interest. So the Secretary of State can make more regulations in relation to transfers for important reasons of public interest, but can also restrict transfers in the public interest. So can say, we are now not going to allow transfers to a third country. You could potentially envisage, for example, in the event of war, or in the event, for example, when the government did a review of the Chinese technology provider Huawei, and said, actually, we don't think it's appropriate for that entity's kit and technology to be within our networks and ecosystems. Could there be a scenario, in the event where they say, actually, you can't do transfers to a certain country? Behind that decision is the concern that the Chinese government have too much control over those entities. Could there be that kind of decision that, if there was an escalation or a concern was raised or legitimized, that then regulations could be made saying, actually, we are going to say you cannot do transfers to particular entities, countries. That's something to be aware of. So what does it mean for you? You're going to need to monitor for new adequacy regulations being made in respect of third countries, which would reduce compliance burdens once they're brought into force. You'll want to review, once this is in force, previously rejected transfers and existing transfer impact assessments, DPIAs related to those, and even your contracts to reassess risk in light of revised thresholds and requirements. And you'll want to monitor for the making of regulations establishing any new standard contractual clauses, further safeguards, or restrictions on transfers. Next, complaints. This is a big one. Section 103 of the Data Use and Access Act 2025 creates a new right on the part of data subjects to complain to the data controller by amending the UK GDPR and Data Protection Act 2018 with consequential amendments, including for the role of the ICO. So new provisions, section 164A, 164B of the Data Protection Act 2018. This does apply both to processing under the GDPR and Part 3 of the Data Protection Act 2018. So law enforcement processing. Again, we'll address that in this afternoon's session. This provides that a data subject may make a complaint to the controller if the data subject considers there's an infringement. Controllers have to facilitate the making of complaints by taking steps which could include, but doesn't have to be, providing a complaint form which can be completed electronically and by other means. When you receive a complaint, you must acknowledge receipt within 30 days, beginning when the complaint is received, and you must, without undue delay, but with no backstop timetable, take appropriate steps to respond and inform the complainant of the outcome of the complaint. Then potentially the Secretary of State will be entitled to make regulations which could require controllers to notify the regulator of the number of complaints made, and other information, for example, could be the nature of complaints, etc., etc. What does this mean for you? You're going to have to, once this is enforced, you're going to have to update your privacy notices to inform individuals of their new right of complaint, that they can complain directly to you. You're going to have to establish a complaints mechanism and procedure for handling complaints under the new right to complain. You're going to need the resources in order to do that. And you're also going to have to monitor for the making of new regulations requiring the collation and reporting of data subject complaint statistics, which may or may not be brought in. But also, obviously, if it is, that has potential implications, kind of reputational implications for your organisation, and something that board members or others with management control are likely to want to be aware of if that's something that could be published. And also then obviously if you have to collate that information, then if you're a public body, you're subject to the Freedom of Information Act, that could be FOIable as well. So that's something else to bear in mind. We now get on to the changes in relation to the Information Commissioner, starting with structure and focus. The Act introduces several changes to the structure and focus of the ICO. So Part 6, Sections 117 to 120 and Schedule 14 will abolish the role of the Information Commissioner and instead replace it with an Information Commission comprised of an executive, including chief executive, and non-executive members, including a chair to be appointed by the Secretary of State. And once in force, all references in all legislation to the Information Commissioner will become references to the new Information Commission. Section 91 of the Data Use and Access Act introduces additional factors to be considered by the Information Commission in the exercise of its functions. That's what we're going to look at, really, the principal objectives. So the principal objective of the Commissioner will be to secure an appropriate level of protection for personal data, having regard to the interests of data subjects, controllers, and others, and matters of general public interest. Nothing new there. What is new? To promote public trust and confidence in the processing of personal data. In addition, what's new is that in carrying out those functions, they have to regard to such of the following as appear to be relevant: the desirability of promoting innovation, the desirability of promoting competition. That's something we bang on about a lot, or I have banged on about a lot, and that Stephen Almond at the ICO has actually acknowledged that if we don't enforce and apply data protection law fairly, adequately, effectively, that is anti-competitive because compliance will not pay and compliance should pay. So that's an area that the ICO will have to look at. And given Stephen Almond's position on it, I'll be interested to see how that develops going forward. Also, the importance of the prevention, investigation, detection, and prosecution of criminal offences, the need to safeguard public security and national security, these kind of higher children's protection matters. So what will that mean for you? Well, the ICO's or the Commission's focus is going to change. So your risk appetite might change with it. These are the things they're concerned about. They have to have regard to innovation. Well, that might mean they'd regulate less. If they have to think about competition, that potentially might mean they regulate more or regulate big players more. It's worth thinking about, and particularly in relation to children, what that means. You might want to revisit existing projects and previously rejected projects to consider whether the assessment of risk should be revised, and just keep an eye on what the regulator is doing and how this seems to be playing out in future. Transparency, Section 91 introduces a statutory duty on the Commission to prepare and publish a strategy for the fulfilment of its functions and to consult with other regulators as to the manner in which it fulfills them. Also introduces a statutory duty on the Commission to prepare and publish a strategy within the first 18 months of commencement, to consult with other regulators, to report to Parliament. Section 95 requires the conduct and publication of analysis of performance. And interestingly, Section 102 will require the Information Commission to publish a report on its enforcement action, something that it has come under a lot of scrutiny for arguably a lack of effective enforcement. So it'll be interesting to see whether obligation to report on it will actually result in a change of approach. So here are just those provisions. We don't need to dwell on them really for any length of time. I've given you the highlight of what they're going to have to do. But there is going to be greater transparency, worth keeping an eye out on. So monitor publications to ascertain nature, frequency, and target of regulatory and other enforcement action, and any changes in approach, just to inform your risk assessments. It's worth keeping an eye on. Guidance. Sections 92 to 93 of the Act will restate the obligations on the Information Commission in respect of the preparation and publication of codes of conduct, introduce a new mechanism for the preparation and approval of codes, as well as an obligation to prepare and publish an impact assessment. What's interesting here is that not only are we going to have potentially more codes of practice, these are different codes of conduct, bear in mind. So you have codes of conduct, which are industry driven or organization driven, whereas codes of practice are the statutory codes of practice. So the Secretary of State can issue regulations requiring more codes of practice to be issued. We have them currently for journalism, for example, children. And there can be amendments or replacements of those codes. As currently, the Commissioner must consult the Secretary of State and, insofar as appropriate, trade associations, data subjects, and those representing data subjects' interests. But a new change will be the introduction of panels to consider codes of practice. So the Commissioner is going to have to convene a panel of people with expertise in the subject matter of the code, people who are likely to be affected by it or represent people affected by it, give them the code in draft, and get them to report on what changes they think should be made, and then justify afterwards what changes it's making, if it's making any, and if it's not following their advice, why it's not following advice. The ICO will also have to have impact assessments of those codes of practice. So you'll want to monitor for the making of regulations mandating new statutory codes of practice, and consider whether and how you're going to participate in or engage with code panels and impact assessments in relation to renewals of existing codes and any new codes. Enforcement. Section 96 will modernise the ICO's ability to serve notices by permitting notices to be served by email. Section 97 will grant the Information Commissioner power to require the provision of documents as well as information. And Section 98 will grant them power to require an assessment to be undertaken and a report prepared by an approved person, effectively outsourcing the Commission's investigation capacity to a third party. It's really interesting. Whether, of course, they'll use these powers or not is an entirely different matter, but the enforcement powers of the ICO are being beefed up. Section 100 will grant the power to issue interview notices, so to require individuals who are themselves the relevant controller or processor, or who have been employed by the relevant controller or processor, or who have been concerned in the management or control of the relevant controller or processor, to attend for a verbal interview, potentially at really short notice. Section 101 will impose time limits on the Information Commission taking regulatory action, having given a notice of intent once in force. So notices from the Commissioner, this is effectively a rewrite, and with that an insertion. So some of them are the same. You can still, deliver to an individual. There is a specification that delivery is by hand, leaving it at the proper address, etc. What's important is you're going to be able to send notices by email to the person's email address. And what is meant by email address is actually really broad. So that's an email address by the time being published by the time being as an address for contacting that person. So if you've got someone's email address on the website, they can send notices there. And if there's no published address, an address they believe or reasonably believe, the notice will come to attention of that person. Now, happily, they haven't gone the kind of the really broad route and kind of said, oh, we can send it to you by DM on social media or something. But potentially, that's a really broad range of addresses. And obviously, sending it to a corporate body can be to a director, manager, secretary, or other similar officer of the body. That's a really big range of people who could now be receiving notices by email. Assessment notices. So basically what happens is the ICO decides that there ought to be an assessment report undertaken. Then as the controller, you're given the opportunity to nominate a suitable person to prepare the report. The regulator will then decide whether to approve that person or not. If they are approved, then they will be at the controller's cost, have to conduct this review and report. Otherwise, the ICO can, if it's not approved, the ICO appoints their own person, and then there has to be a report. It will be specified what the report has to cover. The controller or processor who's subject to this report process will have to give all such assistance as may reasonably be required to the person preparing the report, and then that report has to be provided to the regulator. So they can outsource effectively at your own cost, conducting assessments of your compliance. That's new, really interesting. Whether they'll use it or not, we don't know. Interview notices I've mentioned are new. They can require people to attend for verbal interview, and bearing in mind that there are criminal law implications if you, for example, perjure yourself, effectively, if you give inconsistent information or incorrect information, then that can be a criminal offence. So that's really important as well. As I said, there are false statements made in response to interview notices, that will be an offence. And that's whether it's intentional or reckless. And then in relation to penalty notices, there is a 6-month backstop, and it won't be capable, as it is currently, of being extended by agreement. They'll have to either do it or kind of get off the pot. So that's where we are there. So what does that mean for you? You're going to have to update your training to ensure that notices from the Information Commission that might be received by email are recognised and directed appropriately. Consider whether you need to update your registered address on the register of fee payers, if that's applicable to you, to try and make sure that you've got an appropriate address. Consider and identify relevant individuals who could act as an approved person in the event of an assessment notice being issued. Are there a pool of independent people, so people who are maybe not your current provider of legal and regulatory advice, but who you feel are kind of could do a good review? So they're going to be fair, they've got the right qualifications, etc., that you feel, okay, they don't advise us, but I'd be happy having them do this piece of work. That's something to maybe think about now, and building your network and meeting different people and thinking about that. Even, having introductory conversations with people just to get a sense of what that could mean. You're going to have to prepare for the financial implications of the potential for an approved person to be conducted to undertake that assessment. I suspect if people are being asked to do these reviews and put their name to them and submit them to the regulator, that's not going to be cheap. So that's something to bear in mind when you're thinking about resourcing. And prepare for the prospect of directors, officers, staff, etc., being required to attend for interview, including the costs associated with legal representation for that, or witness preparation training, given the criminal implications. So if you might want to think, okay, as part of your training and development for staff, and particularly for senior directors, would you want to consider building into that witness preparation training, if you don't already have it, in the event that there were an incident or some kind of problem, unlawful processing, and there was going to be an investigation which could lead to them being called for interview. Doing that kind of training now before there's a problem is often really, really valuable. And so worth considering, particularly when you've got time, you can build it in, you can have group training. There are a number of companies that offer witness training generally. I don't think that's necessarily focused on data protection. So that might be something you'd want to consider speaking to specialist data protection providers about, something we would be happy to talk to you about, but something to think about. So we can all breathe now. That is the whistle-stop tour of all the kind of significant changes that the Data Use and Access Act 2025 will bring into effect as and when they are implemented. Um, so we now have time. We've got about 11 minutes for any questions and answers. There are a couple of questions already in the Q&A. If you have any others and you're still awake and I haven't bored you to death, and you've still got the will to live, frankly, after thinking about all of that, please do drop a question in the Q&A. Alternatively, ping us an email after the event. You can do that through Eventbrite. You can email us at info@handleygill.com, or me personally, Nicola Kane at handleygill.com. Ping us an email, and we'll get back to you if you've got a question. Let me just go first of all to the questions we've already got. Public bodies being able to request information in relation to disclosure, does it become a legal gateway or power? No. The provisions around allowing people to respond to a request, it doesn't force them. They are not under a legal obligation to provide the information, but it will mean that they can provide the information if they're willing to and able to do so without having to do a lot of compliance work themselves around that request, and the response to enable them to do it. So it's just going to make that compliance burden easier. I would suggest that once that is in force, if you are making a request, you should definitely phrase your request and include in your templates a paragraph that says, we're making this request, we're entitled to make it because of these are our powers, these are our functions, etc. And you are entitled, in responding to this request, this is the legal basis you are entitled to rely on. It is deemed to be compliant. You do not have to do any further work. You can rely on that. We'd be grateful if you would. And hopefully that should make that whole kind of process, it should give people more confidence. If you're requesting information, I was previously head of legal at the BBC, we would frequently get requests from third parties for information, materials, whatever, and you'd just be told we want it, and you wouldn't be told why, you wouldn't be told what efforts had been made to obtain the material elsewhere, how it was relevant, etc., etc. So you'd be sat there with the request and you think, gosh, it's quite a lot of work to do to have to try and work out, is this a legitimate request and is my disclosure necessary? Can I fall within a lawful basis? This will cut through all of that if people are willing to do it. So it makes life easier. It should make life easier. Whether people are then practically willing, it removes a hurdle for them. I guess potentially it does give you like a PR type argument that, there's no good reason other than you can't be bothered now to not provide this information, and should it be necessary, we'll rely on that. Something to think about if you find yourself in that situation. Yes, so what are the time frames for other requirements? 2 months for some stuff is actually not really the major provisions. That's 2 months for some provisions around biometric data and law enforcement, which I'm going to talk about this afternoon. So do we have much of an idea what's happening? Not really. There's been some suggestion from the ICO that they are looking to a timetable of around like within the next year, but that's not been kind of nailed down. We expect this to come in on, within 3 months, or this to come in within 6. I do expect that we will get something like that in the future, and in the not too distant future. It could come from the Department for Science, Innovation and Technology. It could come from the ICO. I kind of suspect it will come from the ICO, and we'll get just a bit better of like a timeline if and when we do get that. For the work on the Online Safety Act, we've produced various timelines and kind of even countdowns, digital countdown clocks, which are a bit terrifying actually, but quite helpful, hopefully. And so I'd envisage we'd do something similar. In the chat, we put in the link to our data protection reform page. We were away last week. I was away last week, the rest of the office weren't. So we're a bit behind on updating some of that. But after this webinar, we'll send you relevant information. We will then subsequently upload it there. And as things move on, we'll keep that page updated. We also then always publish stuff on our blog. which is on our website. And we also we put flags to stuff on LinkedIn. So maybe think about subscribing to our e-newsletter. We only send out, usually we just do, it's like once a month. We do a monthly thing. So you're not going to be getting daily, weekly emails from us. If we're going to do like an urgent, let's say we were going to do an urgent webinar because there's been some big change, then you might get like an exceptional email, but otherwise we just do once a month. You can take an RSS feed of our blog posts, follow us on LinkedIn, either me or follow or connect with me on LinkedIn, or follow Handley Gill Limited on LinkedIn. And we will make sure that as stuff comes up, we will spit it out at you that commencement regulations are coming into place. This is what it's going to cover. This is what you're going to need to do. So follow us there. And if we can, we'll try and we'll definitely cover that in our e-newsletter. If we can continue to email you after this webinar, then there's sometimes a restriction on how long after a webinar through Eventbrite we can email you, but if we can, we'll also flag it there. Those are, I think, the only questions we've had so far. So I'm going to give people like just a minute or so to see if there's any more. There is absolutely no such thing as a stupid question. So please do feel free to drop a question in. We've covered a really, really wide range of material in not very long, but hopefully that's given you an idea of the areas you need to just be mindful of, things that either have changed or are going to change in practice, what you might start thinking about now. And you can potentially start thinking about, okay, what would a plan of work look like? These are the things we'd need to do. The problem is, until we know what's coming in and when, there might be kind of 5 different changes that would require you to change your privacy notice or to revisit your DPIA. And if they're not all brought in at the same time, it's kind of irritating because it would mean you'd have to go back and do multiple reviews of the same thing. Hopefully we'll get some really sensible commencement provisions come into force, but at the moment we don't know when the commencement provisions are going to be made or when the relevant provisions will then actually have to be complied with. So it's definitely something you need to kind of keep your eyes on and just monitor and have kind of a watching brief for this stuff. We will do our best to keep you updated. I don't think we've got any more questions. So in that case, I've shocked myself and managed to finish this with 3 minutes to spare. Thank you very much indeed for joining us today. We really, really appreciated it. If you find it helpful, please let people know, sign up for our other sessions. We'd love to see you again. And if you do have any questions, we offer free 30-minute video consultations with me. You can book it via our website. So put in a request. And if you've got any questions, we'd be happy to see you there. Thank you. Have a great day. And for those of you joining us for the law enforcement session this afternoon, we'll see you then.